Hey guys, let us continue with our static portion series. In that we are doing polity, and today's topic is fundamental rights. Fundamental rights are covered under part 3 of the constitution with article 12 to 35. Now, what is the inspiration? So they are inspired from the Bill of Rights of USA. Originally there were 7 fundamental rights, but presently we have only 6 fundamental rights because right to property is being deleted under the 44th Constitutional Amendment Act 1978. So under 44th Amendment, right to property was deleted and it was made a legal right. Presently, right to property was legal right under Article 308. Fundamental rights are called the Magna Carta of India. It promotes political democracy. Whereas in case of DPSP, it promotes social and economic democracy, right? It prevents authoritarianism and despotic rule and place limitation on the legislature and executive. So these are some of the features of fundamental rights. Now what are the fundamental rights? We'll look at them. First is from Article 14 to 18, right to equality, 19 to 22, right to freedom, 23 to 24, right against exploitation, 25 to 28, right to freedom of religion, and 29 to 30, cultural and educational rights, Article 32, right to constitutional remedy. So we'll look at each of them briefly now. Now there are certain rights which are available only to Indian citizens. What are they? They are Article 15, 16, 19, 29 and 30. So 15, 16, 19, 29, 30. Only to citizens. What are the rights which are available to citizens and foreigners but not enemy aliens? So there are certain rights which are not available to enemy aliens. Such rights are called 14 and then 20 to 28. In that we also have to include 21A. Article 14, then 20, 21, 22, 23, 24, 25, 26, 27, 28, and we also have to write 21A. And there are certain rights which are against citizens. Fundamental right against private citizen too. Because mostly fundamental rights are like limiting the state or authority of state. So there are certain rights which are available limiting the private citizen also. They are Article 15, 17, 23, 24 and 32. 15, 17, 23, 24 and 72. So we will look at each of these articles. What are they in detail now. In 32 we can use this particular fundamental right against private only. The habeas corpus alone we can use it, not other writs. Now what are the features? The features are they are not absolute but qualified. So there, if a right has been given that right to freedom of movement, we cannot say that go to northeast without getting permission and say that right to freedom, like we have freedom of movement. There are certain restrictions also. We have reasonable restrictions on our rights. That's why it's called not absolute. And most of them are available against the arbitrary action of state, with few exceptions against the action of private individual. And most of them are negative in character, that is place limitation on the authority of state. Yes, most of them are negative because they limit the state's action or authority, while others are positive in nature, conferring certain privileges on the person. If it confers certain privileges which is positive, if it limits state, it is called negative rights. They are justiciable. If someone is violating our rights, we can go and seek justice for it. Defended and guaranteed by the Supreme Court. In case of Supreme Court, it issues writ under Article 32, and in case of High Court, it issues writ under Article 226. And they are not sancrosanct, that is what, or permanent. They can be amended. And then they can be suspended during the operation of national emergency, except rights guaranteed by Article 20 and 21. So during national emergency, they can be suspended except these particular two articles. And then their scope of operation is limited by Article 31A, 31B, 31C. Their application can be restricted while martial law is in force in any area. So if a certain area is under martial law, that is military rule, then fundamental rights can be curbed, and our rights are also under limitations of Article 31 ABC. So we have, if we look at each of them, when we look at them individually, we'll have a better understanding. So most of them are directly enforceable. So for few, an enabling law can be made only by Parliament is necessary. Example, Article 21A, POA Act, 1989. So there are certain laws which can be made to ensure our right by the Parliament, and certain things are directly enforceable. There is no need of separate law or something. So we'll look at each of them. First is Article 12. What is Article 12? It gives definition of state. State, the word state does not just mean our states, like various states we have, right? This Andhra Pradesh or Uttar Pradesh or Kerala or Tamil Nadu. No, it is not that state alone. State includes everything, like state includes union, it includes state government, legislatures, and also local authority, PSUs, etc. All these things comes under the definition of state. And what is Article 13? All laws that are inconsistent with the fundamental rights shall be void. So this is the basis of judicial review. So Article 13 tells us if certain laws made by the Parliament are not consistent with the fundamental right, they can be declared as void by the judiciary, which is called judicial review. Now the laws include not just Parliament but also state legislature, ordinances, non-legislative sources like convention. There can be certain convention followed, right? Delegated legislation, all these things come under the definition of law. Now word law do not apply for personal law. So it's not applied for personal laws. Article 14, it has two concepts. What are they? Equality before law and equal protection of law. Equality before law. This is a negative concept. What does it mean? Absence of any special privilege in favor of any person, and equal subjection of all persons to the ordinary law. So all these things are called as equality before law. Equality before law, of course, it is a negative concept. It includes absence of any special privilege, and also every person is subjected equal. Now what does the concept equal protection of law mean? This is a positive concept. Everyone is protected equally. First one includes no one has special privilege. Next one talks about the equality of treatment under equal circumstances. So we all have here this story, right? If we ask a monkey and a fish to climb, monkey can climb a tree, but in case of fish, it cannot do it. So we have to give equal treatment under equal circumstances only. And the next one is about similar application of law to all people who are similarly situated. That is why we have certain taxes like progressive taxation, proportional taxation. All these things are related to such kind of law only. And like should be treated alike without discrimination. All these things ensure positive concepts. Everyone must be treated equal, which is important, but the condition, make sure that you give them equal opportunity or you place them at similar situation is what they mean here. So rule of law is a part of the basic structure as pronounced by our court. Now there are certain exceptions to it. What are they? President of India and Governor of the state. There are certain exceptions. No criminal proceeding can be initiated during their office. So while President or Governor is serving his or her duty, that time we cannot initiate any criminal proceeding against them. And then foreign sovereigns, ambassadors and diplomats also have certain restrictions. or exception. Now Article 31C, laws made for implementing DPSP under 39B and 39C. So this is an exception. So for implementing certain DPSP under Article 39B and C, 31C, it says that fundamental rights can be compromised for implementing this DPSP. And then Article 105 and 194, MLA and MP are not liable for any of their action inside legislation. So these are the articles 105 and 194. It talks about 105 talks about MLA and 194 talks about MPs. They are not they cannot be we cannot take action against them for something which is happening inside the legislation. So they have such immunity. And Article 361A, it talks about no person shall be liable for true reporting of freedom to publish proceedings of the parliament and legislation, state legislation. So if something is happening and the media person is telecasting it, and if that incident is true, they cannot be sued or they are not liable for it. And Article 15, what does it say? So we have already covered Article 12, 13, right? 15, there shall not be any discrimination against citizens only on the grounds of race, religion, caste, sex, place of birth. So discrimination on other ground is allowed. So we cannot discriminate between individual on the following ground. We have to remember these ground: race, religion, caste, sex, place of birth. And then no discrimination in giving access to shop, public restaurant, hotels, places of public entertainment applicable to state. So we cannot discriminate anyone in giving access to all these things. And then no discrimination in use of wells, tanks, bathing yards, and then maintained by the state fund for general public, applies to both citizen and state, right? So we cannot discriminate in giving public access, like giving access to temples, wells, and we should not discriminate anyone. Like we cannot ask someone that you are not allowed to enter our restaurant or hotel because you look poor. We should not do like that. And then there are certain exceptions like women, children, SC, ST, SCBC, that is social and educationally backward class. For them, for their empowerment, government can make some special provisions or reservation. That is why we have women reservation, SC, ST reservation in certain places, right? And 93rd Amendment, what does it say? Reservation in private educational institution for OBC other than the minority educational institution. So except minority educational institution, all the other even private educational institution has to give reservation for OBCs, the 27% reservation, right? And then they also apply this creamy layer concept is applicable for OBC reservation. Creamy layer are the people who are like well settled or something like that. They do not need special reservation because of their economic and social condition or status. And what does Article 16 talk about? Equality of opportunity in public employment. In case of getting an employment, everyone has equal opportunity. No citizen can be discriminated or made ineligible for employment of any office under the state and on the grounds of only religion, race, caste, sex, descent, place of birth or resident. Here we have two things extra different from Article 15. What are they? Descent and residence. So we cannot discriminate people on these grounds. So Article 15, descent and place of residence are not present. But in case of employment, we cannot differentiate in someone in giving job, citing that they do not live in this particular place or like that we cannot discriminate. So there are certain exceptions. Residence is conditioned for certain type of employment only by the parliament. So in case of parliament, it can ask residence as a criteria for certain job. For example, Article 371D in Andhra Pradesh. And that is, parliament has made certain jobs available only to that particular state citizen. And then reservation to SCBC. This one again state can provide. We have various state reservation, right? And then incumbent of office related to religious or denominational institution belonging to particular religion. So these are some of the exceptions under Article 16. That is, religious institution and their employment can be made given only to that particular religion. For example, in case of a temple, mostly that particular temple jobs are given to that particular religious people only, because the other people, since this is something related to the religious sentiment of people, they give that job only to that people belonging to the job only, that religion only. And then reservation. Mandal Commission was formed in 1979, was appointed under Article 340 of the Constitution. It identified 52% of the population as OBC and recommended 27% reservation. So Mandal Commission was appointed in 79 under Article 340. They said 50%, 52% are OBC, so we can give 27% reservation to them. And then in the Indira Sane judgment, Supreme Court said that total reservation shall not exceed 50%, including carry forward vacancies. So, if certain vacancies are for particular caste or sect, and people from that caste or sect are not enough or not qualified enough, then that particular job will be carried forward for the next year. So, including all these things, the total reservation should not exceed 50%. This was a judgment pronounced in Indira Sane case. And then merit shall not be compromised. Reservation exists at entry level, not in promotion. But in case of SAST, reservation applies even in promotion also. Then creamy layer to exclude advanced section among OBCs. And then Ramanandan Committee was appointed to identify creamy layer among OBC. Government approved it. So Ramanandan Committee is related to which thing? They are related to identifying the creamy layer in OBC. And even now recently the Supreme Court, the Union Government has appointed Justice Rohini Commission. This is also for sub-categorization of OBC. And then 77th Constitutional Amendment Act, it provides reservation in promotions in favor of SC/ST if they are not adequately represented in the services. So this is about 77th Amendment. It provides reservation in promotion for SC and ST. And then 85th Constitutional Amendment Act. What does 85 say? It provides consequential seniority for SC/ST with retrospective effect from June 1995. Right? So 85th Amendment, it provides consequential seniority for SC/STs. And then 81st Amendment, it talks about, it empowers the state to fill backlog vacancy even if these cross 50% filling. So this was against the Indira Sane judgment. In Indira Sane they said backlogs, even along with backlog, it should not exceed 50%. But in the 81st Amendment, government said we can fill backlog even if it crosses 50% reservation. And in the 81st Amendment, they said consequential seniority for SC/ST. And then Article 17, it talks about abolition of untouchability. It is applicable to state and private citizen. Article 17, abolition of untouchability. We saw certain article which are against private individual right. So Article 17 is one of them. Protection of Civil Rights Act is meant to enlarge scope of this article. Term untouchability is not defined in the Constitution or Civil Rights or Protection Act. So this can be asked. The term untouchability was defined in the Constitution. No, it's not defined. Then practice of untouchability can disqualify an individual to contest in election. So this is a big crime. And then Article 18. It talks about the abolition of title. State cannot confer a title, any title on a citizen or foreigner. So we cannot get certain title like Raja, Maharaja. All these things are abolished along with the independence itself. Citizen cannot accept any title from foreign state. And a foreigner working for Indian government cannot accept a title from foreign state without the consent of brethren. If a foreigner is working here in our country even that person has to seek president's permission to get a title from his or her own country. No citizen or foreigner holding any office of profit shall not accept any present emolument without the consent of the president. And then Bharat Ratna, Padma awards are not titles. So these are awards, they are not titles. Even though they are called as awards, we cannot use them in our suffix or prefix, because there is a practice called Bharat Ratna MGR. Or we used to say certain things, right? It is wrong. We should not use it as a prefix or suffix in their name. So the next article is Article 19 to 22. It talks about the right to freedom. What is the article? Now freedom and the reasonable restriction. Article 19(1)(a). It talks about the freedom of speech and expression. Every citizen has right to express his beliefs and conviction. It includes freedom of press, freedom of information, silence, freedom against ban, right to telecast, advertise, etc. So Article 19(1)(a) is about freedom of speech and expression. We can talk or express whatever we feel. Everyone is free to do so. And there is reasonable restriction. What are they? Sovereignty and integrity of India, security of the state, friendly relation with the foreign state, public order, decency or morality, contempt of court, defamation, incitement to an offence. So all these things are not included. Like there are reasonable restriction. We cannot disturb these things for expressing our feeling, right? We should not disturb these particular sovereignty or security of our state. And what is Article 19(1)(b) talks about? Freedom of assembly. That is, we can assemble anywhere without disturbing others. So every citizen has right to assemble peacefully without arms. They can conduct meeting, demonstration and take out procession. This right does not include right to strike. So it does not mean that we cannot go and do strike. Right to strike is not a fundamental right. It is a legal right. We have to ask some permission and then only we can do it. So this is about 19(1)(b). Here also sovereignty, integrity, public order, and then section 144(c) of CRPC allows magistrate to restrain in an assembly or meeting or procession. So we all had this 144 many times during COVID pandemic, right? So magistrate can restrain right to assemble under 144 CRPC. And section 141 IPC, it talks about that 5 or more person can be made unlawful. So if more than 5 people, if they are assembling, it can be made like unlawful. If 141 IPC was in force, more than 5 people cannot go out together, kind of thing. And then Article 19(1)(c), it talks about that all citizens have right to form association or union or cooperative society. This is about Article 19(1)(c). All citizens have this right to form association. We can go and assemble somewhere under 19(1)(b), and we can form association under 19(1)(c). Sovereignty, integrity, public order, morality. These are the reasonable restrictions. We should not disturb these things. Then 19(1)(d). What does it talk about? Citizens can move freely throughout the territory of the country. So we can move freely. But the interest of general public and protection of interest of tribals has to be kept in account, right? For example, while entering a tribal area or northeast region, we need to seek certain permission. So these are some of the reasonable restrictions. Then 19(1)(e), freedom of residence. Every citizen has right to reside and settle on any part of the country. We can go and settle in any other district or even other state. People have such freedom. General public interest, protection of interest of ST. So in case of tribal area, again we cannot do so. Then Article 19(1)(f), I think, which is removed by the 44th Amendment. Yes, Article 19(1)(f) is removed by the 44th Amendment. Now we have Article 19(1)(g). Citizen has right to practice any profession, occupation, trade or business. General public interest, professional and technical qualification, licenses, etc. are necessary. However, state can monopolize the business. So this is about Article 19(1)(g). Citizen has the right to practice any profession. So we all have right to practice any profession, occupation, trade or business. But the general public interest is a reasonable restriction. Someone without medicine degree, they cannot go and do practice medicine, right? So these are some of the restrictions. We need certain technical qualification and license for certain job. And then these are the 6 rights. These 6 rights are protected only against state action and not private individual. So this is against state only, not private. Important rights include Article 19(1)(a), freedom of press, no right to strike, RTI, etc. In 19(1)(a), it includes freedom of press and information, but not right to strike. Freedom to move in and out of the country is not available under Article 19. It is available under Article 21. So we can move within the territory, like given here in Article 19(1)(d). Within India, we can move freely. But in case of moving out of India, if you are going to a foreign country and coming back, which comes under Article 21, right to liberty, not under Article 19(1)(d). Now the next article is Article 20, protection in respect of conviction of offences. So there are certain article explanation and other points, we have to look at them. First, there is a protection available to every person against conviction, right? So first one, no ex post facto law, that is no retrospective. If certain thing is not a crime as of now, but tomorrow government can bring certain law and they cannot arrest someone who did that offense today, because when that person did a crime, it was not an offense, the law was not introduced, right? So such thing is called retrospection. No person shall be convicted by applying law backward, we cannot apply it. But still, for civil cases we can do so. Applies only to criminal laws, not to civil and tax law. Do not apply to prevention, detention. And then no double jeopardy. No person shall be prosecuted and punished for the same offence twice. We cannot give two punishment for a person. For the same crime, we cannot punish the person twice. Available only to proceeding before a court of law and judicial tribunal, not before departmental and administrative authorities. For example, in case of departments or administration, if a person is being suspended, after that, if the management feels so, they can even dismiss that person. So these things do not come under double jeopardy. And then no self-incrimination. No person shall be the witness of his or her own case. Someone cannot go and say that I am that person. If they say so, we need proper evidence for that, like blood sample, specimen signature, thumb impression, exhibition of the body, product of material, object are not covered. So if we have certain evidence like that, then that person can accept. Until and otherwise, they cannot do self-incrimination. So these are the things. No post ex facto law, applicable only on criminal law, not civil law. These things we already saw in the tabular column. Then double jeopardy, applicable in case of court or tribunal only. No self-incrimination, applicable only to criminal cases, both oral and documentary, not in case of civil proceedings. Like even the self-incrimination, it is for criminal cases only. In case of civil, like it is okay to do self-incrimination. So that's all in this part. Thank you.